Loud. Okay, so we've got this recording to the cloud. So welcome to Michele Goldberg with the Law Office of Michele Goldberg. She's going to get started and talk to us a little bit more about guardianship. We do want you to put your questions today in the chat box. I'm going to monitor the chat box for you today, Michele. And so as we have questions, I will read those out to you. So I just gave them a brief introduction. So I'll control the slides. And we'll get started by the disclosures that you have to give. So I'll turn it over to you, Michele.
The disclosures? You want me to read the disclosures?
No, I just know you've got to have them on the screen, but you certainly don't have to read them for sure. So, okay. So today's topic, Michele, as you know, we're talking about guardianship and one size does not fit all. You know, when we're talking about that, and you're saying, you know, one size doesn't fit all, can you share a little bit, you know, because you know the law has shifted in Texas over the years, and isn't there, you know, something in place about like the least restrictive, most appropriate? Can you tell us a little bit more about that in Texas?
Exactly. So first of all, we need guardianship for people that have some sort of mental disorder. If someone is okay, and I've known people, I know people who have ALS, for example, who are severely physically handicapped, disabled, but they're mentally, they're okay. You know, they may have side effects from the ALS, but they can manage their own affairs. They can speak to the doctor directly. They can handle their own bank account. They can manage a credit card, etc. But if you've got a special needs child that has any form of mental disorder, intellectual disability, something on the autism spectrum, any of the disorders, severe anxiety disorder. A lot of people that have mental illness have a high IQ and are very intelligent, but the mental illness could impair their judgment. So anyone that has difficulty making decisions for himself or herself, I'm old school and I'm still using him and her, pardon me if any. We need to look at your child. Each child's unique. You can't just say, oh, my daughter has Down syndrome. Well, there's a whole range. My son's on the spectrum. We're on the spectrum. So we need to look at what's most appropriate. As the child's turning 18, you are the natural guardians. The parents are the natural guardians until the age of 18. But over the age of 18, there are different ways to be able to help your child make decisions. So if your child needs a full guardianship, that's a legal proceeding. And if you are named as the guardian, you become your now adult child's surrogate decision maker with full legal authority to make decisions on his behalf and to override him. The courts also want to know before the judge will appoint a guardian did we examine the less restrictive alternatives to see if that's appropriate for the child? So for a high functioning person, then powers of attorney might suffice, and the Supported Decision-Making Act, and I'll talk about those in more detail. But when somebody calls my office and I interview and in my office, I don't just make an appointment. My assistant doesn't just put them on the calendar. I like to talk to the parents or the family myself and get a feel for the child. And I always ask, sometimes it's hard for the parents to explain exactly what's going on. So I'll ask, does your child see the doctor? How often? Many doctors. Could your child converse with the doctor, have a coaching conversation with the doctor without your assistance? If, for example, if the doctor wanted to change your child's medication, could your child ask the appropriate questions? A lot of 18-year-olds couldn't do that either because they have to learn because mom or dad have always been taking care of them. But if your child has ongoing medical needs, especially if your child's very frail, then I really want to discuss that with the parent to figure out, can the child communicate directly with his medical care providers and make decisions that are appropriate for himself, or will the parent need to be there? That's one of the examples. Ability to manage bank accounts, ability to speak up for himself at school, at the planning sessions. Here in Texas, we call them the ARDs, admissions, review, and dismissal. That's the planning for the coming year or whatever else they plan for. If your child is employed, would your child be able to advocate for himself with an employer? So those are the kind of things that I ask for.
That's good. And I think, a lot of people have questions. And I think one question that I have, Michele, is like, when we have a lot of families that come to us every week that say, hey, we're hopeful and optimistic. Maybe my child's on the spectrum. He or she isn't there yet. So like technically at age 18, then, the answer is no, they can't do a lot of those things that you just mentioned, but we still believe that they're going to get there. Is a least restrictive, a less restrictive, like partial guardianship more appropriate, or maybe power of attorney? I guess what I'm getting at is if we have a family and they're hopeful and optimistic, and it's likely that their child is going to get there. They're not quite there yet. Like you said, a lot of 18-year-olds neurotypical are not there yet at 18. So it's not just, individuals with disabilities. In that example, would you recommend a less restrictive option? Because you can always upgrade later if you need to. What would you recommend in something like that?
That's very well put, Allison. So in that case, I would, if the child, the now adult child, is high functioning, and the parents, well, one thing, yes, I would recommend, if it's going to work for them, the powers of attorney. Can I say what the limitations on the powers of attorney are? So when I'm talking to someone like that, like your example, one of the things I ask.
Hang on, say that again. I want you to say it again. It cut out on my end. So what are the limitations with the power of attorney?
Yes, the limitation. Okay. The limitations on a power of attorney, one is that they're very easily revoked, and I'll give you an example in a second. The other is the third party that you presented to, a doctor, a bank, a cell phone provider that's just given your child credit, might say, we don't take powers of attorney. You got a power of attorney, doesn't interest, we don't accept that. We will deal with your child directly and only. Well, he signed this power of attorney so I can come in and talk to him. So, and maybe I should explain what a power of attorney is and what a guardianship is, so it's a little clearer. But those are the two limitations. Let me just briefly explain, if that's okay, Allison, what a guardianship is and what a power of attorney is. So first of all, you are your child's natural guardian up until the age of 18. 18 is the bingo age. That's on everybody, everywhere in the United States, on everybody's 18th birthday, we don't apply, it's automatic. The child becomes an adult by law. And what does that mean? Well, some people call it the age of consent. What does that mean? Well, you can get your own bank account, your own credit card. You could move out. You could get a job. You could go off to college. You could decide to take a year gap course before going to college. You make your own medical decisions. What's happening legally is, and this is a constitutional right, when we're 18, we're granted all of our constitutional rights. They're all important. But one of the biggies that I see especially with the special needs community, is the right to enter into a contract. And we do that each and every day and don't even think about it, especially since we're online with everything. But that's our bank account, our credit card, our mortgage, our rent, our car note, insurances, medical consent, dental consent. These are some of the many contractual relationships. Your cell phone bill, your cable. These are some of the many contractual relationships we get into. So when I'm asking parents questions, what I'm trying to figure out is, can the kid manage those things on his own? And once again, it's not just a question of growing up and getting experience, but can he really handle those sort of things? If he cannot, then you may need the guardianship. When you get guardianship, those rights are taken from your child. They're given to you, the guardian, so you can protect your child. And sometimes that's what you need to do to be able to protect your child, especially if the child is low functioning and frailer.
Okay, so we have a few questions that I want to ask you.
Okay.
But before I ask you some of the questions in the chat box, I would like to ask about capacity. So, we see from time to time families that do not have guardianship, some because they've just never explored it, and some definitively don't have it because they don't want it.
Correct.
But then we've seen families that don't have guardianship where their loved one does have an intellectual disability, let's say an IQ of 50, 55, right? Okay, so well below 70.
Right.
So, and then it's been determined that that individual simply doesn't have capacity to understand and sign a power of attorney. So,
Right.
what about cases like that? What do people do?
Yeah, and okay, this is tricky. Let me just say this before I answer it. The power of attorney, you don't go to court. It's an agreement between two people. And what you just said, Allison, is key. There are two requirements to sign a power of attorney. You have to be 18, that's easy. But you have to have capacity to understand what you're signing. So I've seen people where the IQ is 50 and it can be a high functioning person, but does that person really have capacity to understand what they're signing? And if they don't, the doctor can definitely refuse it. The doctor might say, she didn't have capacity to sign that. I don't have anybody to sign medical consent. What happens? What happens if they haven't explored guardianship? They could be nothing happens. So they go through life and everything's fine. I personally witnessed, and from professional experience of doing this for many years, I would not leave that to chance, because if there's a medical emergency and you have nothing, and the doctor says, I need somebody to sign medical consent, then, but your daughter can't understand what the risks and consequences of this medical procedure that she needs, you got a problem. You could have a real problem.
And you're at risk of the complete unknown, because you whoever they're in front of. So one doctor might say yes one day, and the other doctor or hospital might say no the other day. And so, it's anybody's guess on how that's going to go. So I just wanted to bring that up, because it's a common thing that we've seen over the last several years that has kind of unfolded. But we have some other questions, and some of them are ones that we've never had before. So I'm going to read it to you. I have a nearly 17-year-old son with an intellectual disability plus autism. My wife and I aspire to place him in a group home by the age of 25. My biggest concern about him living outside of our home is the possibility of him getting someone pregnant. Do I have any legal path to getting him a vasectomy, even though he does not have the cognitive function to understand what it is or why it's necessary?
Okay, that's a medical procedure. You have to discuss it with the doctor. If you are appointed legal guardian, the restrictions on a guardian concerning medical care is, and these are from the Supreme Court, like the Supremes and Washington kind of Supremes, the Supremes, guardians cannot consent to sterilization or abortion. So, but that's a medical procedure, and you need to speak with I guess a urologist if it's a son, and see if you can have the medical procedure done.
Okay, thank you for answering that, and thanks for putting that question in the chat box. We've never had that one come up before.
It's a very good.
Okay, it is a good question. Okay, and actually we have seen this more recently, where it was on the female side, but the female with the disability became pregnant and had a child, and yeah, so we've definitely seen this. If a parent has guardianship of their adult child and they want to give authority to someone else to be able to make decisions and talk to doctors, etc., on behalf of the person with the disability, basically manage the person's care, can they put a POA in place, or can a POA be put in place if the guardianship exists? What do they do? Or could there be like somebody else on the guardianship, a co-guardian, that could help with this?
Okay, that's a very good question, and it comes up a lot. Remember, guardianship's also for the elderly, so this comes up with the elderly especially. So let me tell you what the law is, and then let me tell you how we're allowed to handle it. The law is that only a judge can appoint a guardian. Only a judge can give legal authority, full legal authority or partial legal authority, depending on the situation, for one person to take over and to make all the decisions on behalf of another adult. However, a lot of people under guardianship have a care manager, a care provider, a care manager, especially when we're talking about the elderly. the adult child is mama's guardian, mama's widowed, and she's got dementia, and they hire a care manager. There's a form that you can fill out for the care manager to take to the doctor to be able to communicate with the doctor, but only the guardian can make the decisions, and that's the law.
So in an example, like the previous gentleman, like let's say his son is 25 or older and he's now living in a residential facility, and we all know of very well-known ones across the state of Texas.
Right.
So in that example, he could give care manager, so maybe like that facility might be taking him to the doctor, and so they can talk with them, but the ultimate decisions will hang with the guardian.
Correct.
Got it. That's another great question. Thanks for answering that.
Very good question.
And then the next question, and then we'll continue on with your slides. And this is a good one. It comes up every time. Can guardianship be reversed and a less restrictive option be put in place if the adult gains more independence and becomes able to manage more things?
That's a very good question, and it tags on to your earlier question when we started, Allison. What happens if you have a kid maybe on the spectrum and you think he's going to be okay, but right now you need that full legal authority because maybe he has, in addition to the autism, maybe he's got behavior problems and the powers of attorney aren't going to work. And I want to talk about that just for a second, and so you get the guardianship. I personally, and I'm just one person, I personally, since COVID, have worked on 3 different cases where we went to court and we had what's called a restoration because the person's rights were restored and the guardianship was totally terminated. The courts like to do terminations, and the way terminations of the guardianship, restoration of all rights. The courts like to do it, and the way we do it is the same way we get the guardianship. The medical doctor has to make that recommendation.
Gotcha. Okay, thank you. Are we still good on this slide, or are you ready for the next slide?
I want to say something just real quickly about the power of attorney. Well, I have something to say, and it's flown out of my head. But, the powers of attorney are so easily revoked. They don't have to be revoked in writing. So I've used this example because this was a real case in my office. I'm going to smudge the facts, but the young adult had Down syndrome and her IQ literally was 53. You use 55. It literally was 53. Plus she had medical problems. And she had to have her blood drawn regularly. And so the mother, I told them that I could not do the powers of attorney. I didn't believe that she had capacity because of her IQ. So they found somebody else to do powers of attorney and took it to the doctor. And when she went to have her blood drawn, the girl, she's only 18, started screaming, no, you can't draw my blood. No, I don't want that needle. I don't want that needle. That's a no. And the power of attorney was revoked. If you're the guardian, your child goes into the legal status of a minor child. So just like when your child is little, and any kid, doesn't have to be one with disabilities, any kid, you take them for their vaccines, their shots, and no, I don't want a needle, I don't want a needle. And you say, I know, honey, I know you don't want it, but you're going to have it because you need it. That's how it is when you're the guardian. And I told that to that mother, but she didn't want to take her daughter's rights away. So I remember sitting here.
This is a very good point, and I wanted to bring something else up as it relates to the power of attorney and the healthcare power of attorney, because so there the child has verbally kind of revoked it, but it can be revoked at any time. So if maybe you don't, and hopefully you don't, but if you have an adversarial child. I mean, some 18-year-olds without disabilities are adversarial. They can buck the system at any time. As soon as they're mad at you, as soon as you tell them no, whatever. I mean, they can, revoke that power of attorney at any time.
Right.
So I think that this is especially important in considerations. We've seen a lot of increased mental health crises over the last couple of years since COVID, and people being a threat to themselves and others and things like that. So those are some other things that what we always say is this is a very personalized decision, and attorneys like Michele are poised to talk you talk to you about your family and your situation, and poised to direct you in the right direction. And when you go to an attorney, you don't have to know what you want. They're there to help you and help talk through everything about your child and what might be the best, and talk to you about the doors that you can walk through and what the impacts of each of those choices are. So we've got a couple of other questions. My child still needs lots of supervision when it comes to money management, health management, etc. But is now able to work and wants his driver's license. He has the skills for that. Can the guardianship allow him to hold a job with support and get a driver's license if he passes the test? And Michele, I was thinking that it's a partial guardianship that might allow some of those other rights that a full guardianship takes away. Can you talk about that?
Yes. So I'm here in the Houston area, and I work in, I know you've got people from around the country. This is very judge specific, court specific about the driving lessons. To get the guardianship, a medical doctor in Texas anyway has to fill out an evaluation of the person's capabilities, abilities, and capacity, incapacity. One of the questions is, can the person operate a motor vehicle? Some judges, when someone goes under guardianship, say not driving. Sometimes we go in there and we go, he's already been driving for 5 years. Well, we will allow him to keep the driver's license. It's very judge specific. You can have a partial guardianship. What happens with employment, a person can be under guardianship and be employed. There's no stop there. What the guardianship will do, though, is limit the person's ability or remove it altogether to have a bank account and to manage his own money. And so you need to look at that. And that's a fine line too, Allison. You're talking about there's a lot of nuances with this. So if you say, well, he can have a bank account, but it should have a limited amount of money. Well, how much? Well, $50 at a time, a week, a month, what is that? And if he gets a bank account, then he's going to get those credit cards, they come through, or you get a debit card. So like, can he manage that? You really need to have a close look at the person's abilities or lack of abilities. If he's working and can manage a job, especially if it's full-time and can drive, I wonder if he needs a guardianship, or if the less restrictive alternatives might not be more appropriate.
Gotcha. And then someone said, where can we find a care manager document, and they didn't say this, but I'm adding, or is this language that's added into the guardianship, or where does this care manager thing come into play if we're,
it's a separate document. I have one that I will prepare for my clients. I just did one for someone. They're going out of town. They're leaving the child with an aunt. The child is 30 years old already with an aunt, but this particular person under guardianship is very frail medically. So I prepared something for him that just said, I grant my sister, and put the name on that, authority to communicate directly with the doctor, and whatever. I use some of the language that you see in the medical release forms. The doctor has the right.
Okay, I gotcha. So it's not the same thing. It's a separate document, and that's something that if you have guardianship of your child and you are leaving them in the care of somebody else, then you might want to have that signed before you go out of town. And then I think, Michele, a lot of these facilities, like for residential facilities, they have their own document. That's kind of like a release, or allowing them, because the person is living there. They typically have their own forms in that regard. Do you agree with that?
I agree with that. And then just to answer your person's question, whoever sent that chat in, it's not a legal document that we file with the court. It's something like the facility prepares, or I prepared for my particular client.
Okay, here we have one more. Can you speak about what is the best timing for establishing guardianship in relation to the special needs individual turning 18? I'm asking because my intellectually disabled son is 1 year and 1 month away from that milestone.
Okay, so first of all, you can do guardianship at any time. You can do it for a 30-year-old, for a 50, 60-year-old or older, whenever it's needed. But if you plan to do it when your child, to have in place after your child's 18, the law allows us in Texas to begin 6 months before the 18th birthday. You cannot begin earlier than that.
Okay, perfect. Thank you. You guys are asking great questions today, and I appreciate
really
it.
good questions.
everybody learns when people ask questions because somebody else has it. Sometimes they're shy and they don't put it in there. So,
It helps me
let's talk about some of these social media dangers, Michele. Talk to us about that.
Oh yeah, I just did one. I just did a guardianship for a girl who is just, and she's, you don't have to be pretty to be prey to a predator, but she happens to be a real beauty, and her poor brain, just the wiring is off. She's got borderline intellectual capacity, but numerous mental disability, mental illness related type disabilities, and her judgment is so impaired, but you can't see the disability. But she just turned 18. We just got the guardianship, and she definitely needs the guardianship because she is prey. She's on social media, and some guy, she was giving out guys her home address and her mother's cell phone number, and then they were asking for the credit card numbers. And one guy actually showed up at her house. Her mother testified in court about this. It turned out he was in his late 40s. She was just turning 18. So, I mean, just creepy. And it's very difficult. Even if you're the guardian, okay, you can get them out of it, but to keep people off of social media, that's an in-house policing thing, which is not easy. The mother got, and I'm no expert on social media, but the mother got all kinds of blocks and locks and whatever else, had to take her name off the local tax appraisals, and because the daughter was putting them out there. People were showing up.
Well, we have addressed this topic once before. We need to do it again because a lot of our families do struggle. This is a real issue, and there are things that you can purchase. Bark, B-A-R-K, is one of them, and they're really good if your children are minors. And that's where it starts becoming the slippery slope. So here this girl turned 18. She's 18 years old. Well, you can't monitor their phones anymore like that. It starts being against the law. So there are a lot of protections in place, like Bark. You should check it out. I think they're like $9 a month, but it monitors everything for medically concerning content, suicidal ideation, kind of vulgarity, or any kind of bullying. Basically, I mean, our kids text so much, we can't monitor all of that. So just know that that's out there, and you can check that out. But there is some serious dangers out there for that, for sure. So I'm glad you brought that up.
Yeah, let me just say real fast.
Okay.
I'm not familiar with Bark, but I would argue that because somebody's under guardianship, they are in the legal status of a minor child, and I would hope it would apply, but I'm not familiar with Bark.
So in the example that they're under guardianship, but I guess not a power of attorney or anything like that. I think it's really a questionable area of violation. It's pretty questionable. So somebody put in the chat, and this is true, and I'm glad that you've brought this up. We have guardianship of our son, and he wants to attend a residential transition program at a college. But we found that most residential programs won't accept students who have guardianship. Is there any way around this? We have been running into this more and more in the last couple of years, where if there's a full guardianship in place, that they won't take your student. I would say, now we do have college panels and things like that and other webinars that we've done on that, but Think College is a good place to pose that question. But Michele, what is your experience? Tell us about your experience on this, or if you have any background or have a workaround for this.
I don't know that I have a workaround, but I am familiar with this. And I know I don't want to say the name of the college, but there's a college here in Texas that's really good, and they have the transition program. My understanding, because I did speak with one of the directors of that particular program, and what she said is, we're a transition program, and our focus is to get the person to be as independent as possible. So the programs are, at least that program is geared towards very high functioning people. If they're already under guardianship, I really don't know what to tell you. They might just not be able to go to that program.
I would say that we do have a list of the programs in the state of Texas, and all of them are different, and the different levels of functioning and the different target audience of the program, and different sets of rules. But to this parent's point, I think it is smart of all of you, if you're considering higher education for your student, and if there's a particular program in mind, I would ask them what their rules are if there is a guardianship. I would ask that. I would know that early. And the only other point that I would make, and you guys can check out our YouTube channel on this topic, is explore these programs early. They don't have continuous enrollment. They may only have 3 or 4 slots that they're filling. So know what the programs are, apply to multiple programs, and then, kind of find out what the rules are. But that's a very good point.
And may I just a quick comment about that. If your child is high functioning enough to be able to attend be accepted to and attend one of those programs, then you may want to try the less restrictive alternatives, the powers of attorney, the Supported Decision-Making Act. Do that first. And then if that's not enough protection, then you can always do the guardianship. But I think you might want to try the program first.
And then also each of those schools, what I did as a parent is I evaluated the offices of disability of each of the schools that we were looking at. They're not all created equally. Some of them are good and some of them are just not. And so evaluating the Office of Disability to determine if they have the tools and resources and supports to support your student and the accommodations that they need, I think are important. And there are also a lot of programs on the college level, like TRIOS, for instance, that are there to really support students. So looking into all of those things, I think those are all important. And just know that whether you're looking at community colleges or universities, none of them are created equally. It doesn't even matter if they're in the same town. They all have different sets of rules that they play by and different targets. So you're going to have to, I always say, create your spreadsheet and kind of check them off the list.
Great. Do you want me to address the slide here, or did you have more questions? We can't hear you. Well, I think I've talked about these, that these are the kind of questions that you want to ask yourself, just like I asked the client at your child. And I know some of you are not in Texas. Here in Texas, we call them ARDs. I mentioned it before, and you probably know about them, but that's the planning meeting. And there's a committee. When your child's 18, the school can say you can't attend. You want to make sure that and if your child says, no, I want my mommy here, my daddy there, well, great, there's no problem. But especially when we have mental illness, sometimes the kid will say, I don't want my parent there. Is that going to be okay? And we talked about employers, and you need, these are the kind of questions you need to be looking at. You want to go to the next slide? I love these pictures that you put together here. Okay. Yeah, in my opinion, and in my office, I office with actually real estate attorneys, but we all have, my kids are grown, I've got grandkids already, but a couple of the other attorneys that have college age kids, they did powers of attorney for their kids and they don't have disabilities. Everybody needs some kind of legal protection. If there's an emergency, if you can't make a decision for yourself, whom do you want to name to make that decision on your behalf? So that's your powers of attorney, and you either need that or the guardianship, but you should be looking at something for all of your kids, but especially for your child with special needs.
Thank you for saying that. That's an important point. I bring this up a lot. Our neurotypical kids that go away to college, if they have a mental health crisis and they end up in a mental health facility and you don't have this, you don't have your healthcare power of attorney, they may not even tell you where they took them. You might be trying to call around from mental health to mental health facility. By law, they're not supposed to tell you. So if somebody does tell you, you just got lucky. But there were a few years ago, we had a client whose child was in the apartment fire at Texas State. So these are examples. Okay, so these are examples of times where this power of attorney, healthcare and power of attorney. But I just want to add one more, and I know from a time perspective we're going to keep moving, but I want you guys to have intentional conversations with your aging loved ones in your life. Maybe It's parents or grandparents or aunts or uncles that didn't have kids or whatever, making sure their power of attorney, their healthcare power of attorney is in place. So if and when they become not of sound mind, that you can easily provide, or the help that they need can easily be provided. It's really important. So it's we just take kind of just a little break to just say it's not just your special needs kids. So thank you for bringing that up, Michele. It's so super important. So tell us what it is like to meet with an attorney starting if I'm my kid's going to turn 18 within 6 months and I'm thinking about, oh my gosh, what should I do? Tell us about starting this process and what it looks like.
Okay, and that's a perfect question, because I cannot emphasize enough when you talk to an attorney, because any attorney can file an application for the appointment of a guardian. You don't have to work in this area. It can be you need to be a licensed attorney in your state. But I can't emphasize enough, you want to find an attorney that works in this area. And I hope that one thing you'll walk away with from this meeting, this webinar, is are the kind of questions that I ask and that I think you want to hear from your attorney. Tell me about your child. What is his level of functioning? Because it's a functional analysis. You can say my child's on the spectrum, but if he can handle things for himself, fine. You don't need guardianship. But if the functional level is low, then you might want to look at guardianship. Guardianship attorneys do not always know about government benefits, and they don't have to. But I think it's really essential, if you have a special needs child, you want an attorney that has like at least some familiarity with government benefits that you may be able to apply for your child, and the type of planning that you need to do. And I always look at it as when clients call me, I always think long-term special needs planning. I'm thinking of what government benefits the kid might be eligible for or not, how to get them on Medicaid if that's possible. Do the parents have a good estate plan? If something happens to the parents, is there somebody there to take over and help with this kid? Have they planned a trust? Because if the child has a mental disability, he might not be able to handle money on his own, especially an inheritance. And if he gets an inheritance, will that interfere with his benefits? So you really want someone that you can tell has familiarity. Okay, the person can say, "Oh yeah."
Michele, I always say, look, if if we have a heart condition, we're not going to go see a cancer doctor or the PCP. Right. Your situation is specialized. You need to work with a specialist. Okay. And an attorney that works in special needs is specialized in these things. They are nuanced in this. They eat, sleep, and breathe this, so they don't accidentally mess you up. Financial advisors that are specialized in special needs, that's what they do. They eat, sleep, and breathe special needs. That's how they work. And when you see people that are not nuanced, there are plenty of professionals out there who dabble in special needs, and we see them every week. And I know you do too, Michele, things that are a mess, things that they're just wrong. We see things where they're putting, Medicaid payback in a supplemental needs trust. I mean, we see all kinds of disastrous things. So my advice in general is two things. Number one, when it comes to special needs planning, it comes to these documents, it comes to money in the right buckets, planning for benefits, this is not a do-it-yourself project. No. You do need to hire a professional, and we recommend hiring professionals that are truly nuanced in special needs. And you'll end up, you're going to end up saving money doing it that way anyway, because of all the issues that we see on the back end. You end up paying the professional, you end up paying twice is what you end up doing. Because you pay the first professional that does it wrong, and then you pay the other professional to fix it. So it's basically what ends up happening. So I couldn't agree with you more on that, Michele.
And the reason we put in the slide there that the attorney needs to talk about guardianship, the attorney should be in your geographic area. I get calls. I live in Dallas, near Dallas. Can you represent me there? You really want an attorney that lives in the area, that knows the court personnel, that just has familiarity. I can practice anywhere in the state of Texas. I could go to El Paso or San Antonio or anywhere, but it's really better to have somebody in your geographic area that knows what goes on in your locale.
And that's for guardianship purposes, because it's very judge specific by county. But when it comes to a special needs trust or other things like that, you can draft that for anyone, anywhere in the state.
Yes, and I do them for people all over the state. I do them for people in other states.
And I've heard that before. Thanks for bringing that up. But I have heard before, it is county specific, and so specific that if you have guardianship in one county and you move to another county, then you need to get your guardianship moved to the county that you move to as well. Can we talk about, just for a second, I know you talked about the medical form. So when they're starting the process for guardianship, there's a form that has to be signed off on by a doctor, a medical doctor, an MD. How often does that form have to be signed? Do they have to get that re-signed once a year? Or, I've heard that, you have to have this within so many days of applying for guardianship. Number one, I want you to talk about that. And then also, what do you have to do once the guardianship is in place? Because there's some kind of certificate or something that happens once a year, I think. Can we talk about that?
Yes. So, and this is all in Texas. Guardianship law is probate law. It's all in the Texas Estates Code. So none of this is made up. It's the legislature puts all this into the code in every state. It's your state legislature that puts it in there. But as I said earlier, we can begin the guardianship process 6 months before the 18th birthday. Is a little tricky. A medical doctor licensed in this state has to fill out this particular evaluation form that all the courts require. If you ask me, the form needs to be revised, but that's another story. And the doctor has to have signed it, not just signed it, seen the patient within 120 days, within 4 months of when we file the application for guardianship. Okay, we're also allowed to use a DID, a determination of intellectual disability, that was done within 24 months of when we have the hearing date. So it's a little difference, but it's important in the courts. And we don't have to get that renewed unless there's a court order. Unless in the court order it says that, for example, I have a guardianship of an older woman. She's in her late 70s, who has suffered with schizophrenia her whole life. Her adult sons are her two guardians. In her court order, it said, the judge said she must be reevaluated annually. But that's a very unusual situation. For your special needs kids, usually it's the one time only that you need the doctor's evaluation. That must accompany the application for guardianship. Once you are appointed guardian, you are in the courts. You are under the supervision of the court. And the only thing the court asks of you, not just asks, requires, is that you fill out this annual report excuse me, on the location, condition, and well-being of the ward. It's in the Texas Estates Code that the clerk's office puts out this fill in the blank form. I promise it takes less than 10 minutes to fill it out. It has to be notarized, but you send that in each year. And what the judges say is, look, I have so many guardianships in my court alone, let alone in the county, especially if it's a big county like Harris County, and where Houston is. And how will we know if something happens to the guardian? And the form's really easy. They just want to know where the ward is, the person under guardianship, where the guardian is. Does he live at home? How often do you see him? Things like that.
One thing, and I know that we're, kind of coming around the bend on time, but what we have seen over the last few months, we've oddly seen an increase of physicians refusing to sign these forms. And I don't know if it's like continuing education where they were all told not to sign the guardianship forms or what. But so what happens? So if I have a long-time physician relationship, my child has gone to the same pediatrician for all these years, and we take the guardianship form, and I mean, it's apparently obvious to everybody else that the guardianship is necessary, and the physician simply won't sign. Then what? Do we go to another specialist, another doctor? We just pop around until we get somebody to sign it? What happens? And why is this happening right now? I've just seen this in the last few months.
Oh, I've seen it throughout my career. But so we'll often call the doctor's office first and say, I always ask when I'm interviewing the parents, I always say, tell me who does your child see the doctor? Sometimes they only go once a year. The pediatrician will say, I don't know him. The mother brings them. The mother gives the history. Kid doesn't really talk to me very much. Then I'll say, well, let's get a DID, the determination of intellectual disability, and a determination of autism. And then maybe you can take that to the doctor, which would help. But some doctors, I if the client comes to me, my office sends the doctor the evaluation form with a cover letter, which I don't know if they read it, but I put in bold and underlined it. You do not have to come to court to testify. The courts will accept these without live testimony. I think some doctors might think they have to show up in court or they're going to be subpoenaed. They're not. Usually they're not, but sometimes a doctor doesn't want to do it. Well, you have to find another doctor. Some of the kids have multiple doctors. So I'll say if he has a psychiatrist, that's the best one to do it because that person knows how the brain is working, the functionality. If not a neurologist, pediatrician. So you just have to find another doctor. I don't know this experience of seeing it more. I don't know. We kind of, this is one of the things I screen in the office. Who are your doctors? And I have the names of some doctors in this area that we can recommend that the parents go to. It's usually going to be private pay. They won't bill insurance because what the doctors say is, you're gonna have to private pay me because the evaluation is for forensic purposes. It's not for medical.
No.
Not always.
Okay. So we've got two questions. How does guardianship work if you move to another state? Is it basically voided, or do you just have to what happens if you move from one state to another?
Very good question, because the guardianship law is state specific. We each have our own laws. They're pretty similar from state to state. Some states call it conservator, like Tennessee, California. Some other states call it conservator, not guardian. That can be confusing. But what you have to do is initiate the guardianship in the other state, notify. I've done several, over the years, I've done many, but in recent years, I've done more. It seems like it's coming up more. You start the guardianship in the other state and then notify me. I just did one now in Fort Bend County, close to Houston. I think that's where you are, Allison, where the young man moved to Colorado. And so his family in Colorado initiated a guardianship there. And then I got the court order from Colorado and I closed out the guardianship here in Texas. It's not just a court proceeding that you can just close out, because when there's a guardianship, the judge has determined that this person lacks capacity to take care of himself. And sometimes the court will just close it out, but usually the court needs to know and have on file that there's a guardianship in another jurisdiction, another place that's protecting this person.
So this person says, what if you don't initiate in the other state? What happens? So if you've already got guardianship in one state and you do not initiate it in another state, do you basically just not have guardianship at that point?
No, what'll happen is when you send in your annual report, that is required, and they really read them. I keep telling clients, they read them, you got to send that thing in. It only takes a few minutes, but that annual report we talked about, the judge will see, because it says, where are you? Where's the ward? The guardianship follows the person under guardianship, the ward, that's the legal term. But the guardianship follows the ward. So if they go, well, the ward lives in Pennsylvania now, or Colorado, or Costa Rica, wherever, the judge will say, I don't have jurisdiction over him anymore. He's not in my county. I can't make decisions or limit his abilities because he's not a resident of my county. And the judge will say, you have to do something.
Gotcha. So we're almost out of time, and we're going to send you guys a copy of everybody's of the slides and the recording, so you'll get an email of that later today. But could you just take the last moment and tell us about supported decision making? Because we've talked about guardianship, partial guardianship, where they can have some rights, like driving a car. Maybe they could vote, something like, along those lines on partial guardianship. But let's talk, and we've talked about POA, but let's talk about supported decision making, and let's end with that.
Okay, and I will be fast. First of all, the powers of attorney that your special needs child would need, because there's several powers of attorney for special needs kids, even for college age kids that are, whatever your term is, neuro, whatever, fine. They need a medical power of attorney. I add some things in there. There's the statutory durable power of attorney for business and decision making. For business and decision making, I add things in there about having the ability to communicate with the Office of Disabilities. You mentioned that at a college. And then there's the HIPAA release, the consent to disclosure of medical records. The Supported Decision Making Act, and honestly, I'm a little bit on the fence with it, but I do think it's a very valuable document. I think parents should sit with all kids with it. What it says is, and it's a form and it's put out by the legislature, and we use the statutory form, it's set in a statute. that says the child, the now adult child, is the decision maker, and he appoints his mother and father, or his older sister, or his Aunt Lucy, or whoever, or just his mother, whoever, just his father, to help him make decisions. He still has to sign the HIPAA, which is the consent to disclosure of medical records, and he still has to sign the FERPA, the consent to disclosure of educational records. There are protections in there if it's thought that anybody's using it to abuse the person, because there are a lot of predators out there. I'm not sure that it has any legal bite to it. The powers of attorney, your now adult child has said, I give my mother or my father or whoever the ability to make a medical decision on my behalf, as long as I don't speak up and revoke it. I'm appointing him as my decision maker. On the Supported Decision Making Act, the child, your now adult child, keeps that decision making ability for himself, but just says, I'm asking my parents to help me make my decisions. So I'm not sure legally how much bite it has, but I think it's very valuable because it really forces the parent. I think all kids should sit down, all kids. Sits the parent and the child down together to discuss, what are you making decisions about? Medical stuff, dental stuff, school, bank account, etc.
Some states don't have a supported decision making, so that's one thing to note. Some states don't have that. It is a good thing in Texas. And then we've seen a lot of families, and I just want to end with this, where they have the supported decision making agreement alongside a power of attorney and the healthcare power of attorney. Are you a proponent of that?
Yes.
Okay, that's what I thought. We see that a lot, and and some families will argue like, well, what do I need a supported decision-making agreement? Isn't that what parents by nature? That's just what we do. We help our kids make good decisions. We try anyway. But the thing is once they're 18, then there's less places that are willing to have that input. Some places still do, and the places that still do, oftentimes they're actually in violation of the law. When they're letting you do things that they're not supposed to be letting you do. But anyway, definitely it's a good document in the state of Texas. Well, as always, Michele, it has been wonderful partnering with you today. You bring a lot of information and good advice to the table. And guys, the biggest takeaway that I hope you took away today is that you don't have to have all answers for everything. Partner with professionals. We can help you. We can help you along the journey and kind of talk through do a lot of listening of what is important to you, what you see the future is, and can definitely provide guidance in the right direction. So Michele is in the greater Houston area. She can help you with your special needs trust, wills, powers of attorney, healthcare power of attorney all across the state. Guardianship is specific to Harris and Fort Bend County, more specific to Harris and Fort Bend County. Are there any other counties?
All the counties, all the contiguous counties, Montgomery, Brazoria, Galveston.
Okay, all the ones that touch Harris, all in and around the Harris County in the greater Houston area. So thanks everyone for participating, and thanks everyone for your awesome questions today. It's been a pleasure, and you'll get this email later today with a copy of the slides and the recording. Thanks so much, Michele. Have a good one.
Thank you.
Bye now.